Derek has a perfect candidate across the cafe table. 12 years selling commercial HVAC, calm references, available Monday. Then she turns his offer packet to page 6. Her face changes, not anger. Math. The non-compete says she can't work anywhere similar within miles for 2 years. Pause. She slides it back. Derek copied that clause from an online template 5 years ago. He barely remembered it. To him, it was protection. To her, it was a trap. The hire walks. Derek loses a producer who might have covered $40,000 in monthly accounts by spring. The clause protected nothing that day. That's the non-compete hangover. The federal drama fades, but the old sentence in your agreement still affects recruiting, cash, and credibility. In September 2025, the FTC voted 3-1 to dismiss its appeals and accept the federal rules vacatur. Open Agreement's 2026 guide puts it plainly: no federal rule bans non-competes right now. State law does most of the deciding. So if you heard non-competes are banned, then stop thinking about it. You may be carrying outdated confidence into today's hiring conversation. The 2024 FTC rule would have barred most employee non-competes nationwide, but a federal court set it aside before it took effect. That leaves small employers in the messy middle. Not lawless, not simple. 50-state reality, payroll pressure, and templates nobody has reviewed since launch. Derek's shop has 11 employees, 2 trucks, and 1 operations folder called HR Stuff. That folder decides whether great people trust him. Here's the founder-level question. What are you actually protecting? A relationship? A recipe? A pricing model? Source files? The answer changes the document. A blanket non-compete tries to lock the whole building. Better protection usually locks the rooms with real valuables without blocking exits. For Derek, the real risk wasn't that a former salesperson could ever sell HVAC again. It was customer poaching and margin data walking out. That's a narrower problem. And narrow matters because many states look harder at restrictions that block ordinary work instead of protecting specific business interests. Even without a federal rule, the FTC may still challenge particular non-compete practices case by case under Section 5 authority over unfair methods. J.D. Super's 2026 update notes that several states use pay thresholds, so enforceability can depend on role, wages, and location. That means your warehouse lead in one state and your sales manager in another may need different language, not the same copied page. I know. Nobody started a plumbing company to track covenant statutes, but ignoring the issue can cost a hire before revenue ever starts. Pull every offer letter, employment agreement, contractor agreement, and handbook section that limits work after someone leaves. Put them in one folder today. Then make a simple table: worker name, state, role, pay band, customer access, trade secret access, and whether they signed anything restrictive. If that sounds boring, good. Boring beats discovering during a dispute that your agreement doesn't match the state where your remote employee works. Derek found 3 versions: one for employees, one for contractors, one from a manager who downloaded a template during the pandemic. The worst version covered interns, installers, and senior salespeople alike. Same restriction, same radius, same term. Very different business realities under one roof. Start replacing the blanket with a toolkit. First tool, confidentiality. Plain language that defines what stays private even when the job ends. List the real confidential materials, pricing sheets, customer contacts, job costing formulas, vendor terms, proposal templates, source code, designs, recipes, and operating playbooks. Don't call everything confidential. Courts and candidates both respect precision more than panic. If everything is secret, nothing sounds meaningfully protected. Second tool, trade secret controls. A clause helps, but access control proves you treated the information like it mattered inside your business every single day. Use password managers, role-based permissions, clean file ownership, and named folders for sensitive assets. Free tools may work if the process is disciplined. Derek realized his sales margins lived in a shared drive every installer could open. The document was stricter than the operation. Third tool, customer non-solicitation where allowed. This usually targets active poaching, not someone's ability to earn a living in the industry. Have counsel tailor this one. Some states limit it sharply, and vague customer definitions can turn a practical clause into a recruiting red flag. Define the customers carefully. Clients the employee worked with, learned confidential information about, or had meaningful contact with during a recent period. That feels less scary to a candidate. It says, don't raid the relationships we paid you to manage, not change careers if you leave. Fourth tool, invention assignment. If people create code, designs, training materials, photos, formulas, or product improvements on company time, ownership should be clear. This matters for tiny teams. One freelancer's logo file or one developer's checkout script can become an expensive argument during a sale. Ask your lawyer for language that fits employees and contractors separately. Contractor ownership often works differently, and assumptions get pricey fast during onboarding too. Derek had a contractor build a maintenance calculator. No assignment clause, no repository handoff, just a paid invoice and a prayer. Fifth tool, clean offboarding. The cheapest protection often happens in the final 48 hours, before frustration turns into ambiguity and while memories are fresh. Create a checklist, collect devices, revoke logins, transfer customer notes, confirm file return, remind them of confidentiality, and document open account handoffs. Do this for friendly departures too, especially friendly departures. Most disputes start with blurry boundaries, not villains, and everyone remembers the exit differently later. Lower voice. Here's the hard part. Some owners use non-competes because they feel betrayed before. A top employee left and customers followed. That hurt is real, but the document should answer the business risk, not the emotion from the worst Friday you've had. Candidates can smell fear in paperwork. A broad restriction says, "We don't trust you yet," before you've even handed them a laptop. A narrower agreement says something different. "We protect customer trust, confidential work, and company assets, while respecting your career after us without suspicion." Open agreements notes the vacated federal rule was removed from federal regulations in February 2026, reinforcing that state-by-state analysis remains central. Translation for us: before hiring in a new state, don't reuse the hometown template. Spend the legal money before the offer goes out. That review may cost less than one lost hire, one delayed start date, or one angry letter from a former employee's attorney. Build a covenant decision tree. If the role has no customer access and no sensitive information, consider no restrictive covenant beyond basic confidentiality. If the role touches customer relationships, consider a tailored non-solicit where allowed. If it touches product creation, add invention assignment with counsel first. If the role touches pricing, strategy, or processes, tighten confidentiality and access controls. Match the tool to the asset, not anxiety and role reality. Derek rewrote the sales agreement with counsel. The new version fit one page less but explained the why, much better for new hires. He called the candidate back, not to pressure her, to say, "You're right to ask questions, we fixed the agreement." She didn't accept immediately. Good candidates rarely do. But the conversation changed from distrust to diligence, which is where hiring should live for both sides. When a candidate asks about restrictive language, don't get defensive. Walk through what it protects, how long it lasts, and who it applies to. Put a short, plain English summary before the legal document. No hidden surprises. No burying the operational deal under dense paragraphs before signature day. That summary isn't a substitute for legal review. It's a trust tool, and trust tends to reduce friction in hiring conversations and cleaner expectations. If this episode is useful, give it a quick follow. It helps other owners find practical signals before small paperwork becomes expensive. The FTC's September 2025 announcement followed earlier litigation over the rule, including the Ryan case that set it aside before implementation. That's why headlines can mislead. A national ban being gone doesn't mean every old non-compete suddenly works, or that every state treats them alike. Think of this like cash management. You don't protect cash by taping the register shut. You reconcile, limit access, and keep records. Restrictive covenanters work the same way. The best protection is usually a system, clear agreements, controlled access, documented handoffs, and respectful exits. Set a 30-day cleanup sprint. Week 1, collect documents. Week 2, map roles. Week 3, call counsel. Week 4, update onboarding. Then train whoever hires. A revised template fails if a manager promises, "Don't worry, this never matters," while the candidate reads scary language. Make the restriction part of your culture, not a gotcha. We protect the business, and we explain what that means during every interview. Derek's next offer packet felt different. Same company, same trucks, but the paperwork finally matched the way he wanted to lead. Softly, the win wasn't a tougher clause. The win was a better signal. This owner knows what matters and doesn't overreach. For small businesses, that signal matters. Recruiting is expensive. Trust is expensive. Confusion is expensive. Clean documents may help protect all three when markets tighten. Before your next hire, ask one question. Would a thoughtful candidate see this agreement as reasonable or as a warning sign? If you're not sure, that's the answer. Consider having an employment lawyer review it before the offer, not after the problem. The bigger picture is resilience. Protect the assets that create cash without building a wall so wide it blocks the people you need. Your old template may have served a scared version of the business. The next version needs precision, credibility, and cleaner operations now for the team. This content is for educational and informational purposes only and does not constitute financial advice. Always consult with a qualified financial advisor or business consultant before making significant financial decisions. Remember, this content is for informational purposes only and is not financial advice.